Hi everyone, and welcome to today's webinar. Today's topic is on industrial obligations for community legal centres facing funding cuts or restructure. So we've got a small group with us today, but hopefully we'll get through some really valuable and important content. My name's Carly and I'm from Community Legal Centres Queensland, and I'd firstly like to acknowledge the traditional owners of the land on which we're holding this webinar. So in Brisbane, they are the Turrbal and the Yagara people. I wish to pay my respects to their elders, past, present and emerging, and acknowledge again the very important role that Aboriginal and Torres Strait Islanders continue to play in our society. So today's webinar is being viewed by people throughout Queensland and a couple of others around the states of Australia. So I'd like to pay my respects to the traditional owners of the land throughout the country and extend a really warm welcome to any First Australians who are listening in today. So today's webinar, as I mentioned, is going to sort of talk about some of the important industrial obligations for centres, particularly those who may be facing funding cuts or trying to restructure their service. So, this comes up in uncertain funding environments, and at the moment for community legal centres, it's mostly quite okay, I think. But, with 3-year funding agreements, obviously the time might roll around where things may change and possibly where restructure may be required in order to maintain organisational sustainability. So therefore, it's essential for community legal centres and other community orgs to have a really clear understanding of their industrial obligations and their responsibilities regarding their staff. So today we're joined by Rebecca Gerard, who's the Lead Industrial Officer at the Services Union. Rebecca is going to talk to us and provide some guidance around employment contracts, notice periods, redundancy and reclassification, and help us really ensure a smooth process for centres and staff. So Rebecca, unfortunately, is losing her voice, so hopefully she makes it through the whole presentation, but there is also, she's brought along a colleague, Charlie, from the Services Union, just in case it fails on her today. So please bear with us if there's any issues there. So today's webinar is going to be recorded, and there are some PowerPoints available for you to download just in the handout section. I've also emailed those out to everyone who registered as at about an hour or so ago. So hopefully you've got those in your email, or you can download them afterwards from our website. So we're also going to do a short poll today just at the start, so make sure you put your answer in once that poll comes up on the screen so that we can sort of use some of the feedback that we gain from the poll to help inform the presentation. So I think that's almost everything from me. So very shortly I'll hand over to Rebecca. And we can get started. So I think the last bit is maybe the questions. So if you've got questions, please feel free to type them into the question box or the chat box on your GoToWebinar control panel. I'll hold the questions over to the end unless you've got something really urgent, and read those out for Rebecca to respond to at the end of the session. So I think for now I'll hand over to Rebecca, and I'll come back in at the end. Thanks, Rebecca.
Thanks, Carly. Thank you for the introduction. And I would also like to pay my respects to the traditional owners of the land in which we meet and to their elders past, present and emerging. I also want to apologise in advance to everyone if I do lose my voice today. Like Carly has mentioned, I have brought my colleague along with me just in case. So hopefully we can get through this session without any issues. So as the lead industrial officer here with the Services Union, something that our union is consistently being approached about from our members is assistance in relation to restructures or major changes within the workplace. It's a real issue for employees because that level of uncertainty that it creates can have quite a detrimental effect on their well-being. What we have found, and consistently have found, is that it predominantly affects those organisations who are reliant upon funding. So it is a really topical issue for community legal centres who are reliant upon the funding arrangements. So hopefully you'll be able to get some information out of this that you'll be able to take back to the workplace and put into effect. So a standard clause in all modern awards and enterprise agreements relates to a requirement for the employer to consult with employees when a definite decision has been made regarding major workplace change. This provision has existed in industrial instruments since the 1980s and is particularly relevant in situations where workplace change may result in positions becoming redundant. These enforced consultation provisions are seen by the tribunal, so the Fair Work Commission, particularly as being of benefit in avoiding industrial disputes, and consultations provisions are aimed at providing existing employees with some protection against the effect of the introduction of the changes upon their employment. Consultation is not just a mere formality in the decision-making process. It must really be about engaging with employees and bringing them into the decision-making process. Whilst that might seem like an onerous task when organisations are bound by funding arrangements that sit outside of their control, it is, however, vital that consultation is undertaken, as it is a legislative requirement and something that can be of great benefit to organisations and employees. So I'm just having, there we go. Right, so the Social Community Home Care and Disability Services Industry Award 2010 is the modern award that provides the terms and conditions of employment for employees engaged at community legal centres. This is predominantly the industrial instrument in play, as only a small number of employers in the industry have enterprise agreements. So I'm fairly confident that for the majority of you who are participating today, it would be the SCHADS award that would determine the terms and conditions of employment for your employees. When it comes to consultation with employees, there are a number of clauses that need to be considered within the SCHADS award, and these include the relationship with the National Employment Standards, the consultation provisions, and the termination of employment and redundancy clauses within that agreement. The standard provision relating to consultation regarding major workplace change in modern awards requires that the employer notifies affected employees about the changes and engages in discussions with those employees where the change is likely to have a significant effect on the employee. Significant effects can include termination of employment, major changes in the composition, operation, or size of the employer's workforce, or in the skills required, the elimination or diminution of job opportunities, promotion opportunities, or job tenure, the alteration of job hours or hours of work, and the need for retraining or the transfer of employees to other locations. Consultation provisions must be taken seriously. There is a difference between saying to your employees, this is what is going to be done, or saying, this is what I'm thinking of doing. What's your thoughts about this? And it's only in the latter case that consultation actually occurs. So even if an employer is not bound to follow employee suggestions, they're nevertheless obliged to give those employees a real opportunity to provide them and to consider what that feedback actually is. This means that employers should not make assumptions about the outcomes of any consultation prior to going through that process. So I can give you an example of a case that we took into the Fair Work Commission earlier this year, and it's where the employer was undergoing a restructure, and during that process started to make positions redundant and was issuing the notices of termination during the consultation period. So what that employer had actually done was had preempted the outcome of the consultation period and had determined that no matter what came of the consultation, those positions would be going. So I think they actually let 5 employees go whilst it was in the middle of consultation. So that wasn't looked upon very favourably by the Fair Work Commission, and we were successful in getting the employer to actually hold up and actually go back and try and go through the consultation for those remaining employees. Unfortunately, we couldn't stop it for those who'd already been left, but certainly for those who were still there, we made sure that there was actually a genuine process of consultation undertaken. Right, so just in context, the National Employment Standards are provided for in Section 61 of the Fair Work Act, and they set out the minimum standards of employment that can apply to an employee. So no other condition can be less than what's provided for within the NES, and that can be in a contract of employment or within an enterprise agreement. They can't be any less than these standards. So, a particular note when we're talking about consultation, we need to take into consideration the notice of termination and redundancy provisions within the NES, and I'll touch on those a bit later as well. All right, so the SCHADS award provides for consultation, and it breaks it into two different parts. So there's consultation regarding major workplace change and consultation about changes to rosters or hours of work, and both of those are really important and have different requirements for the level of information that an employer must provide to employees and the different steps that must be undertaken. So Section 145A of the Fair Work Act requires that a modern award must include a term that requires the employer to consult employees about a change to their regular roster or ordinary hours of work, and allows for the representation of those employees for the purposes of that consultation. The term must require the employer to provide information to the employees about the change and to invite the employees to give their views about the impact of the change, including any impact in relation to their family or caring responsibilities, and to consider any views about the impact of the change that are given by the employees. All modern awards and enterprise agreements must include consultation terms that require employers to consult with employees about major workplace changes that are likely to have significant effects on their employment. And consultation under the SCHADS award requires this from employers. So employers are required to provide information as soon as practicable after a decision is made to introduce any major workplace change, and to discuss the changes with employees and their representatives. The discussion should cover the introduction of the change, the effect the change is likely to have on employees, and the measures being taken to mitigate any adverse effect of the change on employees. Employers are also required to provide this information to employees in writing and must give prompt and genuine consideration to matters raised by employees or their representatives. So employers